How you doing, people? My name is KingAce. I'm the leader of the Black Royal Family Foundation, the movement, which is a Black Power movement. We have a 7-point program in which we wish to uplift the minds of the youth, create unity, peace, and prosperity within our communities, get over the monolithic fear of the white man, the subconscious fear that the black collective majority of blacks have of the white man. We want to expose and reform all of America's racist, oppressive capitalist systems. We want to promote and advocate a more positive propaganda, within our communities. We also want one of our main things is to create economic developments within our communities. So with these goals, I understand that it had to start with the youth and regaining knowledge of self, and just having knowledge, general knowledge of everything and all the circumstances going on with the system. Because in order for you to even help change or reform a system, you have to have the knowledge to understand what's going on in the system, and to help yourself get up out of the system. So today I was going to do just a little general, insight about the issue that goes on within the criminal justice system. Not to say that a person should be preparing to go to jail, but in America, the statistics prove that 1 in every 3 African Americans has a felony or is expected to do jail time in their life. So if you find yourself in a misdemeanor, find yourself being arrested for a crime, you need a little bit of insight. I will break a couple things down of what the judge's role is, what the district attorney role is supposed to be, and just a couple little things that you should know. And if you ever find yourself in a situation, now a judge's role, and the judge, the district attorney, and the lawyer, they all are so-called officers of the court. But a judge is supposed to be like the referee. A judge is supposed to be fair, detached, and impartial. So that's throughout the whole proceedings. It's supposed to be fair, detached, and impartial. Now, a district attorney, you might think that the district attorney is supposed to be just the prosecutor and prosecute, but that's actually not a fact, because the district attorney has a dual role. A district attorney has a dual role, not to just seek indictments and conviction, but to see that justice is served. More often than not, when it comes to dealing with people of color or lower class citizens in America, district attorney only exercises the right of prosecution, and they don't use their dual role, because regardless of what the circumstances is, if a district attorney, with their knowledge and their wisdom, they know a person's innocent, they're supposed to not just seek indictments and convictions for a person, but to see that justice is served. So if they know a person's innocent in the interest of justice, like my last case, all of my charges were dismissed in the interest of justice. This is how a district attorney is supposed to move. And your lawyer is supposed to defend you, whether he knows that you're guilty or not. Supposed to defend you. That's the role of your lawyer. Now, when we're talking about crimes, there's 3 types of crime. You have violation, which is not a crime, actually. So let me rephrase that. You have a violation, which is like a fine, and it's not considered a crime. And you have a misdemeanor, which is like a lower type of crime. And you can't, in New York State, a misdemeanor, you can't do more than a year, a definite year in jail, a year or less in jail for a misdemeanor crime. And you got different types of misdemeanors, A misdemeanors, B misdemeanors, but the maximum sentence for a misdemeanor is a year. Now, when you have a felony is a more serious crime. You have all different types of felonies, offenses. When a person is charged with a felony, you go to your arraignment. Usually, when you're charged with a felony, they're supposed to run what is called a preliminary hearing, but in street terms, we call it your felony hearing. Now, a felony hearing is used to protect an inmate's rights. So if they don't have enough evidence they have 120 hours, which is equivalent to 5 days. Only exception that they have to running your felony hearing within 5 days if it's a holiday, and if it's a holiday, you have 144 hours to run your felony hearing. Now, it's the reason why it's important to notice, because a lot of people get arrested and they don't have no real evidence, because police can proceed whatever they want. You can be charged, but for being charged and being indicted and being held past your felony hearing is all different things. Anybody can be charged with a crime, because a lot of these officers that be doing things, they don't really be knowing the proper charges. So when you are charged, say you get charged Monday, they have 120 hours to have your felony hearing. And you know, when you go to your felony hearing, usually you might have a public pretender or a assigned counsel. I call them all public pretenders. You know, you might have some that's in the interest of justice, or they have the best interest at heart for you. But I believe that if you ain't got to pay a lawyer, or if you don't know the law yourself and you ain't putting them on, they're gonna try to fuck you over. So it's important, you know, to know your law, because the law is not as complicated as people try to make it seem. The law was made for a fucking fifth grader to comprehend. So if you know your law and you know these little general things, you might not know everything, but you should know, you know, the little things. When it's time to run your felony hearing, usually they ask you, yo, they tell you, yo, waive your felony hearing, and they give you a lower bail or some other fuck shit. Now, if you waive your fucking felony hearing and they don't have no evidence on you and you don't make that bail, you're gonna be sitting for 45 days. And now you're giving the district attorney an opportunity to indict you. Now, instead of them having to release you, which is a 188 motion, if you run your felony hearing and the people are not ready, district attorney, the people, they represent the people when it's in city court. If the people are not ready to proceed, they have to release you. 188 motion, that's what it's called. So you always should run your felony hearing, regardless if they're ready or not, because it's going to be a determination up to the judge as if the circumstances and the charge, if they have enough, if it's preponderance of the evidence to hold the felony to charge you, to even send it over to the superior court. So it's always important to run your motherfucking felony hearing, never waive it. Always run your felony hearing. Boom. Now, after you run your felony hearing, if you waive your felony hearing or if you run it, some people might waive because they want to get a bail. Don't waive. I'm telling you, my legal advice is don't waive. I'm studying law. Always run your felony hearing. Now, for some incidents, if they have evidence to hold you, you know, because sometimes the judges be biased, they don't be in the interest of justice, and they might act like they got evidence to hold a person. Like I remember one time when I caught a gun charge, and there was 4 of us in the vehicle, and they had no evidence to hold us, but they had the gun. They had the gun. They didn't have no DNA on the gun. They forcefully took our DNA. No DNA came back. They didn't see nobody in possession of the gun, but the judge still held that they had evidence, you know, to hold us because they found the gun in the vehicle, which was illegal. I ended up beating it because they violated my constitutional right of a 4th Amendment illegal search and seizure. You got a constitutional right in the 4th Amendment of the Constitution that you should not be subject to any illegal searches and seizures. And that's how I beat my case. But in any event, let me jump back to what I was talking about. Now, after the proceeding with the 5 days after the felony hearing, if they find that they have evidence and you are in custody, now the district attorney has 45 days to secure an indictment. What an indictment is it's a proceeding in which the people, you know, they go to a proceeding, the district attorney goes to a proceeding with, I think, about 21 people. I'm not sure how many people it is, but it's people from the public. And he presents his case. He has to have a prima facie case. He has to present a prima facie case to get you indicted. And what a prima facie case is a district attorney presents a case to this grand jury. And for every charge that you are for every crime that you are charged with, they have to have evidence for every element of the crime. So for you to be indicted, they have to prove evidence for every element of that crime. Boom. Now, if they don't prove evidence, if they don't secure an indictment within 45 days, now you have your lawyer put in a 198 motion. Any competent lawyer that knows the law will put the 198 motion and you will be released. And it's not over once you're released. Now, once you are released and you are in society, the district attorney, now that you are not in custody, has 6 months. It's speedy trial time. They got 6 months. All the time that counts towards them. If you don't request no motions and if you're not indicted, they have 6 months to indict you or the case is dismissed. Now, if you are, what was I talking about? Okay, they have 6 months to indict you. Now, at the grand jury, you know, they got that phrase at the grand jury that they can indict a ham sandwich. It was kind of true because, you know, a lot of them grand juries don't even really be knowing. A lot of people don't go to their grand jury to try to, you know, prove their innocence. And at the grand jury, you don't have your lawyer present. It'll be you and the district attorney. So if the district attorney is not in the interest of justice, if you want to get you indicted, more likely than not, he's going to be able to get you indicted unless he is being fair and doing his job, which is a dual role that a district attorney has, not to just seek indictments or conviction, but to see that justice is served. So if a district attorney is doing his the job, and he's looking at all, he already knows, what he can prove and what he cannot prove. Because they go to school, they went to school, they study this shit, they know what they can prove and not prove. Sometimes they abuse their discretion, they be arbitrary and capricious. So, boom, fuck that process. Now, just because you get indicted does not mean that it is over. Now, when you get indicted, now it's called pre-trial conference. You have a pre-trial conference that you go through. This is where your lawyer put all these motions in to see if all of your rights were violated. You don't have to just wait to go to trial. When you have pre-trial conference, this is the time to make sure that all of the arrests was valid, that the searches and everything was valid. If you done with anything, when you would search or seize, you have hearings, you have the Darwin hearing, you have the suppression hearing to suppress any evidence, and the suppression hearings are hearing that, let's say for example, I was walking up the street and police pulled me over. This happens all the time. They pulled me over. They had no reasonable suspicion to believe that a crime was committed, that a crime it's about to be committed, or that a crime is in the process of being committed. So, and they decide to go among their means and play as the role of the judge and search me anyway. Now, once I go to court, if I can prove that this search was illegal, they didn't have no probable cause, I wasn't doing anything suspicious, you had no probable cause that a crime was committed, was in the process of being committed, or was about to be committed, everything that was found after this illegal search must be dismissed. Why must